Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson, here alongside Maynard Nexon attorney Fay Edwards. Good to see you again, Fay.
Thanks for having me.
Well, we have our good friends here with us today, Joan and Mim Munzel of the Arbor Consulting Group. It's a national human resources consulting firm specializing in HR risk management and regulatory compliance. Joan and Mim, thanks for being here.
Oh, we're happy to be here.
To be back. Thank you.
Well, we are very glad you're back. In this episode, we are following up on our recent discussion of the Office of Federal Contract Compliance Programs, or the OFCCP, and the False Claims Act. So we're going to start out by talking about the Department of Justice memo from the Attorney General. It's titled Guidance for Recipients of Federal Funding Regarding Unlawful Discrimination, and that seeks to explain what it considers illegal DEI. Can you give us an introduction to this topic and what's behind it and how employers should respond to it?
Certainly. I know it's quite a title, isn't it? So last month on the podcast, we discussed the Department of Justice efforts to use the False Claims Act against organizations that it feels have not eliminated what it considers illegal DE&I. This month, we're going to discuss the Department of Justice's latest efforts to define what it considers to be illegal DE&I and the implications for employers. While employers would welcome some clarification on this illegal DE&I term that's been tossed around, which is especially true because now, as a federal contractor or possibly subcontractor, you're going to have to certify that you no longer have this illegal DE&I in their next contract or if they renew a contract. So this memo provides some clarification, but it also adds to the confusion that we're all feeling out here. We should note the AG's memo does not have the force of law. It's not a regulation. It's not a statute. The courts do not need to adhere to it. Although some of what it outlines is based on law and some court decisions, some appear to be more of what they would like to have and what they would like to be the law. In other words, kind of a wish list. So what this means is that there's probably going to be a lot of litigation on these topics to come. And so we're still left with quite a bit of confusion over what's real, what's not, what's legal, what's not.
Thank you, Joan. And I can definitely resonate with that we're still left in this gray space and just waiting for some clarity. Mim, do you mind telling me what are the categories that put federally funded employers and those subject to the federal anti-discrimination law at risk?
Yep, absolutely. The first category is granting preferential treatment based on protected characteristics. And some of this, I'm going to refer to notes because, it was actually written out in the document. So I want people to understand what it says. In that category, it's providing opportunities, benefits, or advantages to individuals or groups based on protected characteristics in a way that disadvantages an other qualified person. So in essence, you're taking a spot from someone who was otherwise qualified. Now, this can mean race-based scholarships or programs, for example, preferential hiring or promotion practices where you might be prioritizing a candidate from an underrepresented group, for example. It can also mean access to facilities or resources based on race or ethnicity. What we tend to think of here would be like ERGs, employee resource groups. If those are not open to all, that can really be a problem.
Yeah.
The second category is prohibited use of proxies for protected characteristics. So unlawful proxies occur, and this is right from the memo, when a federally funded entity intentionally uses ostensibly neutral criteria that function as substitutes for explicit consideration of race, sex, or other protected characteristics. So, if you're targeting a geography or an organization or an institution that you've chosen primarily because of a racial composition. So things that we think about could be recruiting from an HBCU, for example. If that's not part of a larger strategy and you have a business-related reason for doing so, Women in construction is a group that oftentimes our construction clients look to try to find female representation on their job sites. And that needs to be part of a larger strategy again, so that you're looking for the best qualified, not based on sex or race.
And casting that wider net to get the best qualified against all organizations. But you probably need to document that rationale.
Yeah,
to be
right.
on the safe side.
Right. The third section is segregation based on protected characteristics. So, for example, if you have any programs, activities, training, anything like that separates or restricts access based on race, sex, or other protected characteristics, except for what they called intimate spaces, which, we think of a restroom, for example, would be not under that umbrella. This is where, when companies look for a diverse slate, for example, that's been a common practice. That's going to be a problem now.
You're going to have to be very careful how you do that.
Yeah. Unless, that is the slate of best qualified. But it has to be race neutral, for example, or gender neutral. Contracting or hiring policies that would favor minority or women-owned businesses. Again, in construction, oftentimes we see that where you're trying to subcontract to women-owned or disadvantaged businesses, minority, yeah. And then leadership or internship programs, and this is from the memo, even if framed as addressing underrepresentation. So it's really, the idea is you've got to scrub everything and see if you're on solid ground here. The fourth category is training programs that promote discrimination or hostile environments. And what the memo says is unlawful DEI training programs are those that, through their content, structure, or implementation, stereotype, exclude, or disadvantage individuals based on protected characteristics or create a hostile environment. And what we started seeing around this one would be terms such as white privilege being used in a training program, or toxic masculinity is another one that sometimes gets cited. So that's kind of what we know at this point. More to come.
Yeah.
And what is the AG memo considered to be best practices in this situation?
Well, I'm going to talk about a couple of them. The recommendations go on for 2 pages. I'm not going to talk about all of them. We don't have that much time.
We'll take a sampling.
Yeah, I'll give you some categories. So the first are items I consider on the wish list for sure of what they want you to do, but they can't require you to do, at least at this point in time. So, for example, the memo wants you to put a non-discrimination clause in all your contracts with third parties. Now, I might add there, you've always been, if you're a federal contractor or subcontractor, you've always been required to do that, even under the protected vets and individual with disability regulations. So that's nothing new there. But what is new is they now want you to monitor those third parties for compliance. So how's that going to work? So does that mean that companies and the prime contractors would have to do this monitoring and make themselves responsible for every third party, subcontractor, vendor, whatever, that they engage to make sure they're following all these?
Yeah.
That seems like that's going to be pretty hard to do. Another category are things that I would say no self-respecting HR person should be doing in the first place. So the memo says, well, you need to eliminate diversity goals or diversity quotas. So goals are one thing, quotas are another. No one should have diversity quotas. Those were not allowed under Executive Order 11246 for women and minorities in the first place. The regulation they rescinded, it was very clear that quotas were not acceptable there. And they're not required by the affirmative action regulations for vets and disabled now. So I think the people that wrote some of this didn't really understand those regulations in the first place, but it's very clear, no diversity quotas. Now, some of the things they list as best practices are things I would hope you'd be doing in the first place as a good HR person. So, for example, they want you to focus on skills and qualifications for openings and promotions. This should be this should have been done already.
Yeah.
You know, you always want to make sure that you have the job-related, non-discriminatory requirements for each of your positions. And that just makes sense from all kinds of vantage points, and if you ever have to defend yourself. Now, we have not generally found in our clients that they had a criteria that was geared toward any particular demographic. We have not seen that. What
No.
we were more likely to find is that people were hiring under what we call the Friends and Family Program, which is problematic. Now, if your friends and family are the best qualified for the job, no problem. But if their only qualification is that they are a friend or family member or related to the plant manager or something, then that can be problematic for any organization. So skills and qualifications, job related, non-discriminatory, that's the way to go.
Very interesting. And how you kind of touched on it before, that this is some of the stuff that we should be as HR personnel should be doing in the first place. I always told if it's written, someone's not doing it. So I guess my follow-up question is, how does an organization handle avoiding problems under the AG memo and still comply with the European Union and state and city affirmative action requirements?
Yeah, it's such a good question.
A challenge.
It's really, really a challenge right now. What ends up happening is organizations have a patchwork of regulatory compliance they have to follow. And there's no one size fits all solution here.
No.
You've really got to work with your attorneys to figure out how to proceed. But some places where you could get tripped up would be this year, for example, in the EEO-1 report, the federal government is only allowing you to, for a binary option, so male and female. But many states and some local governments are allowing non-binary employee reporting. So if you've asked your employees to self-ID under this set of non-binary choices, then you have to go back to the federal forms and only select one of two choices. It gets really confusing and hard. Although federal contractors no longer have to prepare AAPs, for example, with regard to race, sex, ethnicity, many states still require that. And so, you're ultimately possibly preparing an AAP for a state that goes against what the feds now tell you is you're not supposed to be doing. So that's really a problem, and that none of that has gotten worked out yet. States like Connecticut, Kentucky, New Jersey, Minnesota, Wisconsin, they're the ones that are requiring female minority AAPs. So particularly if you're doing business for those states, if you have a contract with those states, that's something to pay attention to. Other states, California, Illinois, Massachusetts, require employers to periodically report sex, race, ethnicity, as well as pay equity. So those you've got to take a look at. California is slightly different than the federal reporting, for example, around sex and race and ethnicity. And so, you've got to get your strategy going for how do you make all that happen? And like I said, there's just no one size fits all, because companies are doing business in various states. Not everybody's doing business in all those states, but yet you've got to comply with these federal regulations now that may change, or may not, it's really, really
a moving target,
challenging. And again, there are sometimes federal and state conflicts with contracting to incorporate preferences. So construction projects, again, if you have requirements there, you've got to have a strategy for how to manage that risk if you're required by a state to retain, a certain percentage of female-owned businesses, for example. So that's something to be looked at. And then also there can be state mandated language or even municipal language that you have to include in certain places, and that can run afoul of the federal. There is if you're a global organization, if you're operating within the European Union, they have what's called the Charter of Fundamental Rights, which is equality between male and female, and the right of integration of persons with disabilities. So, among other issues, there is leadership positions directive for board members and management. There's a pay transparency directive that we have all now heard about, but there's also corporate sustainability reporting directive. And a lot of that is going to be very different than the federal requirements in the US. So that has to be figured out. UK and non-European jurisdictions like Japan, Australia, Canada have diversity and equity provisions. And we're not going to go into any more depth around these, but the point being, you got to pay attention here and figure out, don't go blindly.
Right. And again, just emphasizes the amount of balls that are in the air and moving targets. I guess final question for you, Joan, is what should federal and state contractors be doing now?
So one of the things you can do is work with Arbor. We have over 30 years experience working with these different agencies and so on. And of course, partnering with your Maynard Nexen attorneys, because it takes both an HR and a legal approach to review all these programs and processes to make sure you're not running afoul of these targeted illegal DE&I efforts. And we can help you craft a program that'll still allow you to be compliant with non-discrimination laws, but also to accomplish your company goals. Because, with the diversity of the world and your marketing to a diverse world, it's really important to still have a diverse workforce. Remember, you still have affirmative action requirements. Just because, as a federal contractor or subcontractor, you still have requirements for protected veterans and individuals with disabilities. These are statutes. They cannot be overturned by an executive order. We find a lot of people are thinking, oh, well, this is all gone and we don't have to do anything.
Yeah.
But you need to have an affirmative action plan for vets and disabled. You need to have specific reports, and you need to have a laundry list of other requirements that are in those regulations. As suggested earlier, you should also document your rationale for why you are casting a wide net in your recruiting efforts, why you're going to the HBCUs, why you're going to the women in construction, because you want the best qualified people that are out there in all categories and so on, to get the best possible talent. But document that now, because you're now going to have some documentation for proof of that if you get targeted. Review, certainly, as Mim was talking about, all your EU, your state, your city, Japan also has issues and so on, to see if they're going to be in conflict with this Attorney General memo or not, and how you're going to handle it. Make sure also your leadership is informed of these issues and they're aware that they should avoid making specific statements or commitments that may create problems for the organization with this AG memo. I think the kind of bottom line is that each organization must weigh its own potential risk and tolerance for risk to determine its path forward. And we're here to help you make it happen, as I know the Maynard Nexen attorneys are.
Thank you for that. This is a complicated landscape for compliance right now, but it is best to have a strategy to work through it. So thank you for your insight with that. Thank you very much for getting into it with us, Joan and Mim from Arbor Consulting Group, and we will see you next time on Work This Way.